Hi, everyone. Well, thank you for joining us for our intellectual property workshop. We have Shane Coleman. We love working with him. He's amazing. A lot of you, I'm sure, took last week's class. We do have a recording. If you weren't able to catch that, we will definitely get that recording to you. So just reach out to me. And we'll also be recording this one. So this is a 3-part series, and each one will be recorded. We will have them up on our website as soon as our 3rd session is completed. So just a little bit about me. My name is Volcker. I'm a business advisor with the Small Business Development Center. We are a program that is here to help small businesses. We're a free service. We help with one-on-one counseling, business plans, financial projection assistance. We help facilitate workshops like this with content that you guys are needing. And so if you guys ever come up with a topic that you're like, hey, I think this would be really beneficial, if you had a workshop on that, always reach out, because we try to make sure that we're providing the content that's going to be the best for you. So with that being said, I'll kind of just throw it over to Shane if he's ready to go. Shane Coleman, he's a great partner with us. He helps a lot of our clients with intellectual property questions and needs. He's absolutely amazing. He volunteers a ton of his time for different things. So we definitely can't recommend Shane Coleman enough. So I'll just kind of throw it over to you.
Wonderful. Well, thank you, Kayla. And I apologize. I think I've already screwed up my slide presentation again here. It did not go smoothly last week, but I may have to just
Shane, if you want, you could always email it to me and I can try to see if I can do the slideshow. But we can always supply the slides later on too if you're not able to get them going and you just want to get started.
I will get them in some form here. What does that look there? Are you able to see my slide presentation?
Yep, you can see it. I would just say, yep, that's perfect. You can, do it right that way. We can definitely see your slides.
How about, is it better now? Did it change at all?
It did get bigger.
Okay. All right. Well, I apologize again for whatever technical difficulties. Again, my name is Shane Coleman. I'm a patent attorney here in Billings. If anybody has comments, questions as we go through this, please put them in the chat if there is one, or just interrupt me. I'll be glad to talk about those. And I hope most people attended last week, which was kind of an overview of different types of intellectual property. What I want to talk about today are, I've lumped together patents, copyrights, and trade secrets. We've broken these out from next week's presentation, which will be on trademarks and branding, and there's not a lot of great reason to do it other than the concepts of patents, copyrights, at least, and to some extent trade secrets, are all a little bit different than trademarks. They're not based on any sort of a use. As we talked about last week, they're all these are all types of intellectual property that effectively can be created by a company. If you have some sort of an invention or some sort of utilitarian idea, you're making a product that you're selling, you're using a manufacturing process or some sort of software process. That's the sort of thing that might be protected by a patent, it might be protected by a copyright, it might be protected by a trade secret. Conceivably, all 3 of those types of intellectual property could cover different aspects of the invention. So, refresher from last week for those who did not attend or those who did, when we talk about patents, we're mostly talking about utility patents. And Kayla, did the screen advance? I apologize for calling on you.
Yep, you're on the next slide.
I'm staring at different screens in my own office here, and some have advanced and some have not. Okay, so that's the one you have. When we talk about patents, for the most part, I'm talking about utility patents. These are, yep, I changed my screen again. These are things that cover useful inventions, as opposed to Plant patents we touched on very briefly, and design patents. Utility patents probably compose 90 to 95% of all patents that are out there. So I'm mostly talking about utility patents when we talk about those today. Utility patents are the only way to effectively protect and ensure that you protect some sort of a functional system, some sort of a functional device, a mechanical device, an electrical device, a chemical composition, etc. When we talk about copyrights, we're talking about something not utilitarian that is stuck, if you will, in some sort of tangible medium. It's we're talking about things like software code, like books, photographs, videos, sculptures, architectural works, that sort of thing. Trademarks, again, we're not touching on those today, but those are things that identify the source of goods or services, like the golden arches at McDonald's. Trade secrets can take the place of patents in certain instances. These are things that are valuable by virtue of the fact that they are secret, business plans, that sort of thing. So let's jump in. What I want to do is this is similar to last week's presentation, but I've got a lot of, hopefully anyway, a deeper dive, if you will, into a lot of these issues, starting with patents. And again, we talked about this last week. We've got utility patents, design patents, plant patents. We're going to talk almost entirely about utility patents today. Who are, just out of curiosity, I've got a few charts here at the outset for people who are interested, or for those who aren't, I guess. The US companies that have obtained the most patents as of the most recent available data from 2018. And you can see a list of, these are a lot of companies that you've heard of. Alphabet, of course, is Google. Apple, Qualcomm, Microsoft are all in there. Dell. These are high-tech companies for the most part in the United States. It's that have just the sheer volume of patents. One reason I put this up here is, for whatever reason, I get a lot of questions in my practice from people who have not obtained a patent before, who say, you know, do I really need a patent? For people who say, you know, you know, the best way to protect software or an invention is to keep it secret, or to not protect it at all and just go public with it. And those are very viable ways to go about your business, and they may or may not make sense. But I think this slide is useful to explain when, and I hear a lot in the software context, there's no reason to patent software. You know, for better or worse, the high-tech companies, no matter what you may have heard someplace else, they are obtaining patents, and they're obtaining them by the thousands. And I mean, these are not all software patents. I don't have a separate group on those, but the bottom line is software companies like Google, like Microsoft, and I realize they make hardware as well, they have thousands upon thousands of patents. The big players in this business are obtaining patents to protect their work. One reason they're obtaining them, and not so much these established companies, but smaller companies, is the numbers, some of which are shown on this slide here, show that that's frankly what venture capital is looking for. As companies get big enough to attract outside investment, what those companies are, or what those investors are looking for, is some sort of a moat, if you will, for lack of a better corporate buzzword. They're trying to figure out what separates one company from another company. And if it's technology, then the question is, what exactly about the technology it differentiates this company from someone else, and what protects it? I tell clients, and every day when I meet with them, and I think I told this audience last week, that if you are concerned, if you've got a business and you make a widget, and you are concerned that someone else, a competitor, is going to make that same widget and open up a shop across the street from you and maybe steal your employees while they're at it, or maybe it is a former employee, and you're concerned about that competing widget in terms of your ability to operate a business, then you should be thinking about a patent. On the other hand, if your moat, if you will, if your competitive advantage is in non-technical issues. For instance, maybe you make paper clips, and maybe you have the best distribution network of selling, distributing, marketing, etc. Your paper clips, if that's your advantage, you don't need a patent on although I don't have it in the presentation, I used to, a cylindrical coil of some sort, I think is how they define the paper clip, and they have actually patented it, paper clip, different types of them. But the point is, if your distinguishing feature of your company is the fact that you make something that's different, that you would be offended if someone were to copy it, then you ought to be thinking about a patent. And that's exactly what investors on a large scale are also thinking. They're thinking, I want to put my money behind someone that I know has some sort of a legal advantage, if you will. For whatever it's worth, and I've got a couple of slides just on who's been obtaining patents in recent years. For whatever it's worth, the Chinese have been incredibly active in obtaining United States patents right here in the United States. Companies from around the globe, of course, can seek patent protection both in their own countries and in the United States, just like the United States companies based in the United States can seek patent protection in other countries. Chinese firms are absolutely dominating the market in terms of who's filing for patent protection worldwide, whatever that might mean. They eclipse the United States, the EU, and other developed countries just all on their own. And again, what follows to tie the last two slides together, what's following the patents and patent applications that are filed is the venture capital. And as the charts show, just over an 8-year period, the venture capital, at the same time the Chinese, for instance, have been drastically increasing their patent filings, the venture capital has been chasing those Chinese companies as well. The point is they can be incredibly valuable when you've got a patent on the right sort of technology. So again, what I want to do today is delve a little deeper than we did last week into the different types of patents and the patenting process in general. And as a refresher, a utility patent generally protects an idea that's been embodied in some sort of a statutorily protected device, if you will. It protects mechanical inventions, electrical inventions, chemical compositions. It protects this would include processes, manufacturing processes that consumers may or may not ever know about. And what the patent does, I barely touched on this last week, but it grants a monopoly of 20 years from the date of filing of the application. Previously, it was 17 years from the date of issuance. That allows the patent holder to prevent others from making, using, selling, or importing the product or the invention, or whatever the invention might be. It doesn't have to be a product. Let's digress on that just a little bit. It technically, and not technically, it literally is not the right to actually make the invention, as counterintuitive as that seems. But just give a very simple example. If I were to invent a new and useful composition of rubber that could be put in vehicle tires, for example, and it's some sort of a vulcanized process or whatever, maybe I've got a process, maybe I've got the rubber composition, maybe I have whatever. I could claim, we'll talk about the claims in a minute here, but I could claim that composition of material. I could also claim as my invention a tire made from that composition of material. I could also claim a vehicle with the bare minimum number of vehicle elements. Let's call it a frame or a unibody design of some sort, with some sort of a transmission, a steering wheel, and one or more tires, each of which is composed of my new material. I could absolutely claim that. And my patent, and there's reasons to claim it in each of those three examples, as the composition of rubber, as a tire made from that composition, and as a vehicle that includes tires that are made from that composition. There are good reasons, which are probably beyond the scope of today's discussion, why you would do that. That doesn't give me, though, the right, if I hold that patent on that rubber composition, and even if I claim a vehicle having tires made of that rubber composition, that does not give me the right to make that vehicle from the ground up, because it might, for example, that Chevy or whatever may have thousands of other patents involved in it. It doesn't allow me to copy it from the ground up. It only allows me technically to sue other people, if you will, who infringe my certain patent. And in most cases, they end up being the same, but they don't necessarily need to be. The requirements to obtain a patent are that it be useful. As I mentioned last week, that's a really simple hurdle to clear. Novelty, the invention must be novel. What that means is nobody else has made, used, sold, disclosed, etc., that precise invention as you claimed it as the patent holder. Novelty is not terribly difficult to overcome, because you give me a complicated enough invention, we can probably show that it's slightly different than something out there. So where the real action is in the third prong, non-obviousness. That's where the action is, so to speak. The non-obviousness means exactly what it says. It means that the invention is not an obvious modification of the so-called prior art, or an obvious combination of multiple prior art references. And as we get into the process here, when I, as the patent attorney, am arguing with the patent examiner about trying to get a patent on a particular device, and the examiner, on the other hand, is judge, jury, executioner, if you will. It's an adversarial process, but ultimately you need to get the examiner to agree with the patentee or the patent applicant. The patent examiner is going to combine multiple references. That reference A shows these features, reference B shows these other features, reference C shows these other features. Everything that you, patent applicant, are seeking to protect has already been protected, has already been discovered, if you will, or invented by somebody else. And the more references the examiner combines, and it's not enough just to throw together different references. There has to be some motivation on the part of an inventor, a hypothetical inventor, to combine these references. The more references that need to be combined, the less obvious it looks, which should make sense. If the examiner says, here's 19 different inventions, or here's 7 different inventions, I've pulled features from all of them, and on that basis, if someone were to combine different features of each of these, they would come up with the patent applicant's invention. That doesn't look terribly obvious. And in most cases, we're talking about combining 1 or 2 references with a core reference, if you will. But that's where most of the action is, if you will, is proving to the patent office that the invention is not obvious in light of the so-called prior art. And related to this is the so-called statutory bar under Section 102B of the Patent Act. What that means is that the inventor, practically speaking, the inventor needs to file an application for the invention to obtain a patent within 1 year in the United States of first disclosing that invention. And why it fits under here, and if they don't, they abandon it. But effectively, and the reason it's under here is the patent holder, the patent applicant's own conduct in selling, offering for sale, disclosing, etc., the invention will become prior art. It's technically, the invention would not be novel because the prior art includes the inventor's own conduct, if that makes sense. So we talked last week about different types of applications. For the most part, when I talk about a patent application, I'm talking about a normal, the middle one there, a United States non-provisional patent application. these inventions, these applications rather, can claim the filing date of a provisional application. We talked about that last week. It sits on a shelf that never gets examined. It will never become a patent, but it can serve as a placeholder under certain circumstances for a regular non-provisional application. We also talked briefly about foreign applications filed under the Patent Cooperation Treaty, or filed directly with other countries or regions. And again, a United States patent application can claim the benefit of a foreign application, if that makes sense. And when we talk about utility patents, again, we're talking about the right to prevent. Oops, I went the wrong direction here. That we already talked about that. So let's talk about the guts of a patent. What goes into it. And this is the code section or the regulatory regime section, if anybody cares. But in general, a patent is going to have a background section. The patent itself is, let me step back, is drafted, as I said last week, from whole cloth. There are multiple forms that attend to it, but the actual patent is what the patent attorney drafts. And it's up to, and these are, depending on the complexity of the invention, these are 5 to 50 page patent applications that then become the patent if everything goes well. The patent is required to have or application, I guess in this case, a background section. Generally speaking, the background section explains to the patent examiner and to the world how this invention fits into the whole scheme of other inventions. This is if you have a baking device, it would, the background section would probably talk about the prior art related to similar baking devices. And, it doesn't explain what the invention is. It just says, here's all of these other inventions and here's where ours fits into the whole scheme of things. There's then a summary of what the invention is, just a short summary of what's described. And then I want to lump together the detailed description and the drawings. The patent is required to disclose the invention with such detail that it would enable somebody skilled in the art to make and use the invention. In other words, I typically say if we have if our person skilled in the art is an engineer with a couple of years background in this particular field, it's not a complete dummy who knows nothing about it, but to somebody who has some familiarity with the general background, the detailed description of the patent needs to disclose the invention with such detail that someone could go out and make and use the invention. And that's fundamentally the trade-off between between the government and the patent holder. The patent holder gets a monopoly for a period of years, 20 years from filing in most cases. And in exchange for that monopoly, the inventor has to disclose the invention with such detail that someone could go out and make and use the invention. And to the extent there are multiple ways in which the invention might work, the detailed description needs to describe the invention in the best mode, if you will. And there's not a lot of case law on that particular issue, but what it means is if there's multiple ways of using the invention, a method, for instance, it needs to disclose the best way of doing that. The reason I tie it in with the drawings is when I'm talking about a mechanical device, for instance, something I can see and touch, as opposed to a chemical composition, a method or process, software code, that sort of thing. A mechanical device, I need to show drawings of everything that would depict the invention. The drawings, everything that's described in text needs to be shown in the drawings. Everything shown in the drawings needs to be described in text. And the same is true if I have a different type of invention other than a mechanical device. If I have a software method, for example, the method needs to be described in writing. And a lot of times that's nothing but a block diagram with a series of different steps in the process. It's a 5-step process, and those will just be shown in block diagrams. Everything that's in the drawings needs to be described in text. Everything that's in the text needs to be described in drawings. And the drawings, for whatever it's worth, are very specific to patent law. They're for people who prepare engineering drawings, they will find them completely useless. They remove all dimensions. They can't have extraneous text. We hire all of that out to a patent draftsman. And for budgeting purposes, I tell people to plan on minimum $500 to $1,000 just for drawings paid to a draftsman to comply with the requirements. The patent then concludes with claims. So if let's hypothetically say I've invented a table, and my table includes a flat surface, and the drawings show a table with a flat surface, and the table includes a bunch of legs depending from the flat surface, probably 4 of them. That will all be shown in drawings. It will be described in text. That's all well and good, but the claims are what define the invention. And so if I have my table example, what I then say is, okay, having described the table in as best a manner as possible, here's what I really claim. And what I really claim are a smooth surface that's adapted to be oriented in a generally parallel way, spaced apart from the floor, and 1 or more legs, probably 3 or more legs, depending from the surface to the floor to support the table. So having described a table, for example, with 4 legs, 5 legs, 6 legs, I'm now going to claim it, and I'm going to claim the invention in the most minimal way that I possibly can. What that means is probably claiming 3 legs. And then when I go, it's tempting to say that the claims of the patent are the legal portion. That's a bit of an overstatement, but not much of one. The claims of the patent define the invention. That's a so-called Bedrock Principle of, I think that's on my next slide, of patent law. And what I say is, okay, I've described my table, but what, all that really composes the table is a flat surface and 3 or more legs. And I don't have to say 3 or more, I can say 3 legs, because if someone makes a table with 4 legs, and I've claimed a table with 3 legs, a table with 4 legs necessarily includes 3 legs, so they would still infringe. And then finally, there's an abstract, which is essentially a shortened version of the summary. The abstract gets printed on the front of the patent so that the world can quickly understand what the invention is, and it will normally track the claims for whatever that's worth. As I just mentioned, the claims are what really define the invention. You go through as the patent applicant in great detail to describe every single way in which a patent might be, or which the invention might be practiced. If it's a widget, the ways in which the widget might be created or might be used. But then ultimately you define, you say, I claim a table, for instance, with element A, element B, and element C. If someone comes along and they make an infringing table in this example, and they include elements A, B, and C, and then they add D, E, and F, they still infringe my patent. Again, to the poor example of a table, if I claim a table having a flat surface with a first leg, a second leg, and a third leg, if someone adds 19 more legs to it, or even just a single leg to it, they still infringe, as long as they include every aspect of the invention. And that gets back to our concept of, it's not the right to make the invention, it's the right to exclude other people from making the invention. And that's what the claims ultimately define what the patent is. And I'm asked to look at patents frequently where someone has obtained a patent whose only claim is what we call a so-called picture claim. It's a complicated device with lots of features, and I claim every last bit of it. Well, it's when every last feature is claimed as part of the patent process, it becomes very difficult to infringe that patent, because the claims define the invention. And if the invention includes too many words, for lack of a better way to explain it, it's not terribly valuable. We want to get the patent issued with the broadest claims possible in most cases. So turning then to the patenting process, what this looks like is someone comes to our office, they give us some sort of a disclosure of what their invention is. We meet with them typically on one or more occasions. We get drawings from them. We get written descriptions from them. We then file the patent application. And it goes to the patent office where it frankly sits for a period of time before we get back from the patent a so-called office action, a first office action. And typically, other than procedural matters, the first substantive patent office action typically comes somewhere between about 1 and 2 years out. About 18 months is not unusual. And the office action invariably will reject some claims. Sometimes it allows some claims. And in a perfect world, in my own opinion, others may disagree, but in a perfect world, I file the application with broad claims and with narrow claims, lots of claims, typically 20 to 30 or 40 claims in the patent, depending on the invention. In a perfect world, in my mind, some of the claims are allowed, some are rejected, and then we fight with the patent office as to what is allowed and what is not allowed or should be allowed. And the basis of the rejection is almost always, again, there will be procedural matters, but it's almost always based upon the patent being obvious in light of the so-called prior art. And that's where we argue with the patent examiner that no, the prior art does not teach this particular feature. It's where we argue with the patent examiner that no, it would not be obvious, even if the prior art does teach this feature, it would not be obvious to combine these references. And as a result of that, the examiner either agrees with us or disagrees with us. We might amend the claims. For the most part, the patent application, the specification is what we call the written description, the drawings, all of that stuff. For the most part, those can't be amended in any substantive way during the prosecution of the application, but the claims can and are. And in a typical case, we get back a rejection from the patent office. We then respond by arguing with the examiner and also by amending the claims in a way that we think would be allowable. This goes back and forth a few different times, a couple of times at a minimum. And if everything goes well, we get a so-called notice of allowance. And that tells us that a patent will issue at some point, and ultimately then the patent will issue. I don't have any slides on this, but it is normal for our clients, certainly our larger clients, to file multiple patent applications. You can have let's call it a second application related to the same invention, as long as it's filed while the first application is pending. And that's the only reason I have this slide here that identifies the notice of allowance and the issuance. Before the first patent issues, if we're going to file another application, it needs to be filed before that first patent issues. And why might somebody do that? There's lots of reasons. In some instances, the patent office believes the invention includes, or the application rather includes multiple inventions. The inventor thinks it's only one. The examiner says, I see 2 or 3 inventions here. You need to file separate applications for each of these. That's one reason. A second reason might be that the applicant is trying to rush through the patent office to get some sort of a patent issued. That might have claims that are very, very narrow. But then the applicant might also decide, well, I want to keep fighting with the office to try to get broader protection for that invention. So I have a first patent application that issues with fairly narrow claims. I then have a second application called a continuation application or a continuation in part application that seeks broader protection. And you might do that, for instance, because you want to immediately, as the inventor, go out and try to sue somebody on the patent. Or you might want to try to license it, and you want to make sure that you have some sort of a patent. In some cases, and this also happens quite frequently, a second application is filed that might arguably be narrower than the first application, but the claims are specifically targeted at a particular infringer out there. In other words, and this happens again frequently in our practice, the inventor believes that one of their competitors is infringing their patent, but the patent wasn't really drafted, I don't want to say that well, it was drafted to get the broadest protection that the inventor imagined, but it doesn't quite cover precisely what the infringer is doing. So if that application is still pending, if any of the patent applications are still pending, the inventor might file a second application or a third, fourth, 20th, whatever application. That's a so-called continuation application, as long as one of the applications is still pending at the patent office. So that's why the notice of allowance and the issuance are critical. And there tends to be a good period of several, at least 2 or 3 months between those two. So turning then to the application that we looked at last time. I'll see if I can enlarge some of this a little bit on my screen. We looked at the Rubik's Cube invention, the patent application and the patent issued back in 1983. And last time we only looked at the abstract, and I won't try to bore too many of you with that, but the abstract is shown, if I can get it to come up here on my screen. The abstract, oops. The abstract describes this invention as a spatial logical toy formed from a total of, and it goes on and on and on. That describes what this thing is. And if, you know, in practice, it's awfully difficult to put into words what a mechanical device is. I mean, everybody on this video, I presume, knows what a Rubik's Cube is, but how do you go about describing that in words? Well, you know, as ugly as it is, that's what this looks like. And when people talk about a patent having a lot of legalese in it, I wouldn't describe it as legalese. I describe it as very complicated technical descriptions. When you have to put into words what an invention is, that can become tricky. So that's what we have here. This is our patent on the Rubik's Cube. Let me go down. That's again just the first page, and I think the second page of the drawings to illustrate those. What we also have is then, and these are the parts of the invention that I talked about a minute ago. The background section, I'll enlarge that a little bit more here. The background section, I can get there, is short. It just describes how this particular invention, the Rubik's Cube, fits into the overall scheme of things. It's a spatial logical toy. And sometimes this is a particularly short background section, but for a lot of legal reasons, it's good practice to not make it terribly long. The invention background is simply to try to inform the world, if you will, where in the scheme of things this fits. Sometimes some background sections will describe the prior art. I think that's dangerous from a legal standpoint in terms of trying to characterize what the prior art is. But sometimes it will say, you know, this patent or this invention, a different one, teaches, you know, how to do this thing, and a different invention teaches how to do this. But you know, it will sometimes explain the demand or the reason why somebody might go out and get this. But here the background just says this is, you know, that other toys are known, but nothing like this. We then have a summary of the invention, which for all practical purposes is a longer version of the abstract. The abstract, I should have mentioned before, is limited in terms of the number of words you can have in it. So the summary will be a little bit shorter. It describes briefly what the invention is. We then have a summary of the drawings that says, you know, if we recall, figure 1 shows this, figure 2 shows that. And then we get into it's tempting to call this the specification. It's technically the detailed description. And this is where I mentioned earlier, every figure needs to show every element of the toy in this case. And everything that's shown in the drawings needs to be described in text, and everything in text needs to be shown in the drawings. And you'll see references here to 8 identically toy-shaped elements, 1. We've got a solid cam, 2, etc. Those numbers all refer back, and I went to the previous slide. Apologize for jumping around, but those all show the numbers that we see in the drawings. This is the cover page of the drawings here. But you'll have numbers, 1 refers to one of the planar surfaces of the, or one of the toy elements, I should say, of that compose the Rubik's Cube. And you've got a whole series of numbers here in the drawings, each of which then is called out in the text. And I think I only have the one page of, or a couple of pages, I guess 1 slide of this, but it describes in detail everything that's shown in the drawings here. At the conclusion, and again, I've left off several pages of the Rubik's Cube patent, but at the conclusion of the description, I actually maybe I should have shown the page before this. These are column numbers at the top, 5 and 6 here. These are the so-called claims. And what is not shown on my slide is there will be a sentence or a prefatory comment before the claims that says claims, and I claim the following. And they're numbered 1 through, in this case, 7. And it says, having just described the best way to use this Rubik's Cube toy and having shown you drawings and described what's in those drawings, this is what I actually think I'm legally entitled to a monopoly on. And these are these words that I won't read in total, but the gist is you've got a prefatory clause in a toy, et cetera, et cetera. And it goes on to say that, where's the section I'm looking for, that these are the elements. The improvement of this toy is formed by a total of 18 toy elements. Remember, we talked about how it should probably have 27 in the commercial embodiment that we have, but only a 2 by 3 by 3 embodiment is what's described here. Again, they've claimed it broadly in case someone were to make a toy that way. And this is where it says, this is what I actually claim. And what we have going on here then is claim 1 is a so-called independent claim. This will be, by definition, the broadest claim, the independent claim. We get then down to claim number 2, and it says, in claim number 2, I claim everything that was claimed in claim 1, plus some other stuff. And the other stuff in this case are, well, we're going to go further and say that everything that's up here in claim 1 now needs to have a shape of a regular geometrical body in the assembled state. In other words, it looks like a cube as opposed to some sort of irregular 2 by 3 by 3 embodiment. Why do we have dependent and independent claims? Well, there's lots of reasons, but the 2 main ones are during the patent prosecution. That's not the enforcement of the patent against someone else, but it's prosecuting the patent itself through the patent office, trying to obtain allowance. During that process, we start off, hopefully, with many, many claims, and there will be broad claims and there will be narrow claims. And hopefully some of the broad claims are rejected and some of the narrow claims are allowed. And the examiner looks at every one of those claims. For whatever it's worth, you can file 20 total claims, including 3 independent claims for a fixed fee. So that's, most patent attorneys try to get to at least 20 claims and at least 3 independent claims if the invention warrants it. Beyond that, you pay an additional fee per claim. That's pretty modest in the scheme of things, but anyway, that's why a lot of them only have 20 claims. And hopefully, some claims get allowed, some get rejected. And why I say hopefully is I've once in my life had a patent application go all the way through with every claim allowed on the first office action. And frankly, that makes me nervous. It makes me nervous that either I wasn't greedy enough in claiming the invention for the client, or the patent examiner simply didn't do his or her job. And both of those make me concerned. If the patent examiner didn't do a good job examining the application, it's not going to be a terribly strong patent. I want the examiner to look at the prior art and say, you know what, this is different than all of that prior art. I want the examiner in a lot of cases to make me modify the claims. That's one reason. So we, just as a practical matter, we begin with multiple claims in the patent prosecution. Whatever is allowed, we end up taking, and there's multiple ones. The other reason is, practically speaking, lots of patents are held to be invalid during litigation. We talked about last time how the patent examiner, in order to keep his or her job, needs to spend no more than about 10 hours per patent application in order to meet the quotas. And they have a very strict quota system on how many applications they need to get through. And there's nuances to that we won't get into, but that's in obtaining the patent. Fast forward now to a successful invention that is generating, you know, millions of dollars a year in revenue just by virtue of the fact that it's patented, and the patentee sues a competitor for patent infringement. What the once we're talking about millions of dollars, we can, you know, on behalf of that accused infringing competitor, we can spend a lot more money, a lot more time searching the prior art that the examiner maybe didn't find. And so when I'm drafting an application, and I know that when we say a patent is invalid because of, you know, it's already been done, the examiner did not do a good job examining the application, the prior art invalidates it. What we're really talking about in that instance is invalidating the patent on a claim by claim basis. So it's entirely possible that claim 1 in our Rubik's Cube example, the broadest claim, could be invalidated in litigation, but that claim 2, claim 3, etc., might be fully valid. And as long as those other claims embrace the so-called accused device, the infringer's product, then there's still infringement. So if I only have one claim in a patent that's allowed, a person I sue, a defendant, knows that if I can knock that one claim out, I'm home free. If they look and see multiple claims that are all infringed, their job is a lot harder. It's you have to knock out a whole pile of different claims, which may or may not matter to the infringer, but most likely do. Okay, boy, I really screwed this up, didn't I? I apologize here. So, and we've already talked about the claims. I blew that up. This is what we claim. We talked last time about a design patent. I want to just touch on that briefly. Again, the design patent is nothing more. I guess you're not seeing that in this particular patent because I only have the first page of it, but the design patent covers only the ornamental features of the invention. In other words, the claim, if we were to skip to page 2 of the shake weight patent claim, oops, I did that again, apologize. If I were to skip to page 2 of the shake weight patent, the claim here, unlike all of the text that we saw on the previous slide for the utility patent, the text here will say nothing but I claim an ornamental design depicted in the following figures. And that's all it is. All that's there is a handful of drawings. And for whatever it's worth, the dashed lines don't count. What they're actually claiming in this instance is strictly, zoom in on the bottom of our shake weight, is strictly a design that has these particular features. It does not require the outwardly curved centerpiece of the, I guess it's a dumbbell, exercise device, as they've called it here. So that's in stark contrast to a utility patent. We don't have to describe all of that. So I've used the term prior art quite a bit here. To be clear, and I touched on this briefly last week, but to be clear, prior art doesn't have to be US patents. That's an obvious place to find prior art. The patent examiner works at the patent office, and he or she has obviously come across lots and lots of issued US patents. They're very easy references, or prior art references, as we call them, for the examiner to find, but they don't have to be that. They can also be foreign patents. They can be any sort of a publication. If you have a product offered for sale in the Billings Gazette, that could show up, and patented or unpatented, it's not, strictly speaking, a race to the patent office. Any sort of a publication, a printed material that describes the invention or something similar to it, can be used as a reference. Also, public use, which is not on my slide here, can be used as a reference. A person making the invention in Omaha in her garage could easily be prior art. The problem, of course, is the patent examiner is probably not going to learn about that person in Omaha. Patent examiner is going to have a library of commonly used references. Just to digress a little bit, the patent examiners are assigned to art units, and they're very specialized. They are not lawyers necessarily. They don't need to be. They do need to have some sort of a college degree in an engineering science or other hard science, as we call it. But if you have a mechanical device for some sort of an HVAC, heating, ventilation, air conditioning system or unit, you will be assigned undoubtedly to a person who spends all day, every week, every year looking at other HVAC inventions. They're very familiar with this particular field. If you have an automotive claim for a transmission, you will, in all likelihood, be assigned to a patent examiner who looks at transmissions all day, every day, has a pretty good understanding of this. And the examiner, as I talked about earlier, will say, your patent is rejected because it would be obvious to combine one or more of these so-called prior art references together to come up with the invention. And again, to my point a minute ago about the time an examiner can spend talking about or reviewing rather the obviousness or non-obviousness of an invention, and being limited to say 10 hours on average, 10 hours is never going to uncover foreign patents outside of obvious places, the European Union, for instance. Foreign, no amount of patent searching ahead of time by the examiner is probably going to come up with patents that are in foreign countries that are printed only in a foreign language, in an Asian country, for example. No amount of searching at the patent office will ever come up with those. They'll never find the lady in Omaha that made this in her garage. But in litigation, again, lots more can be done to determine that. I want to get into a handful of concepts that come up with respect to the patents beyond. So now we've gotten the patent, or we're thinking about getting a patent. There are some tricky issues in terms of who owns the patent. There's a presumption that whoever the inventor is owns the patent. In the United States, inventorship and ownership are not the same. We keep track of the patents by the inventor's name. We always list the inventor. We don't simply list, unlike trademarks, for instance, we would list the company, if you will, that owns it. Let's look back real quickly at the design patent. Here you'll see the shake weight design patent. It says Verheem at the top of that. The Verheem is the inventor. Mr. or Mrs. Verheem may or may not work for a company, may or may not be obligated to assign that patent to the company. But as a practical matter, every company out there that has employees who invent as a part of their job should have some sort of an agreement, what we would typically call an invention assignment agreement or something similar to that, that says anything made within the scope and course of my business, I agree to assign, and I hereby do assign to the company, just to clear that up. I guess I've had at least one case that went all the way through trial, all the way through appeal, where the inventor, former employee, argued that he built this thing and the company didn't own it. He owned it. It wasn't a part of his job. There was no sort of obligation to assign in writing. And our client was in a pretty bad spot. We ended up winning on behalf of the employer client, but not out, not until we spent literally millions of dollars in fees trying to prove that no, in fact, this individual did not happen to invent this oil and gas product during the 2 weeks he was between jobs. Remarkably, every single inventor out there claiming or individual claiming to own something seems to have always come up with it on their off time in between jobs, that very narrow window of time. But the gist is you want to make that clear if you are an employer. If there are co-inventors, things get even dicier, or co-owners. If they all work for the company, great. If you are the company, make sure they sign their inventive rights over to the company. Otherwise, if we just have two individuals, they don't work for companies, they are under no obligation to assign their inventions. They are both allowed as co-inventors to license the invention is the biggest part of that. Owners are presumed to be the inventors unless there's some sort of an assignment document. Each co-owner can go out and give a license to somebody. So this, I actually attended a seminar the other day on this exact issue, and we spent an hour and a half just on the issue. But the biggest issues where it comes up are, let's say hypothetically, two individuals, they don't work for a company, they just come up with something on their own. One of them goes out and says, I'm going to license this to someone, and they're going to make the licensing revenue, and it's the invention is basically worthless to the other individual. There's no concept of, somebody, invented a small part of the invention and therefore they only are entitled to 10% of the royalties, hypothetically, and the other inventor is entitled to 90%. Absent some sort of an agreement, that's just not a concept that exists. Make it perhaps what might be worst case scenario. You have one, company A that owns a patent suing company B who infringes the patent. But company A's patent was invented by an employee and some contractor outside. Well, company B, the infringer, can go approach that co-inventor and take a license if the co-inventor is willing to grant a license. And it becomes a really ugly scenario where all of a sudden the infringer actually holds a license and a co-inventor can grant that. So the moral of the story on patent ownership is get it in writing to make sure that it's clear. We talked briefly last week about foreign patents. There's two ways to file these: directly with the individual countries. We do that frequently with Canada, where our client only wants to pursue patent protection in the United States and in Canada, or through the Patent Cooperation Treaty. And as I talked about last time, this delays the patenting process, but it can, in some respects, despite the time delay, can streamline the whole process. There's no such thing as an international patent, but it is possible to have an international filing with a priority date that kind of streamlines the process. We talked briefly about infringement of patents and the so-called all elements rule. When we have a patent and it claims my table, for example, with a horizontal surface and legs A, B, and C, in order to infringe, somebody needs to infringe their product, their accused device needs to embrace every element of the claimed invention, whatever is in the claims. If I claim a widget having elements A, B, and C, and they have A, B, C, and D, they still infringe. If they have A and B, but they don't have C, and instead they have D, E, and F, the competitor does not infringe. They're absolutely required to bump up against that intellectual property, if you will, those claims, as closely as they can without infringing. They're absolutely entitled to do that. If there is infringement, what can an infringer expect to pay to the patentee? Again, in the United States, the patentee is entitled to the greater of either a reasonable royalty or lost profits. Almost every instance where the patent holder actually makes and uses the invention, lost profits are going to be substantially greater than a reasonable royalty. These are both the subject of testimony by expert witnesses, economists, marketing experts, that sort of thing, who charge exorbitant rates. And it's nothing to, it's a very complicated analysis, whether we're talking about a reasonable royalty or a lost profits analysis. The gist of a lost profits analysis is the accused, or the patent holder rather, needs to show that it would have captured, if you will, a certain percentage of the infringer's sales, and that it made X amount of profits off of those, would have made X amount of profits off of those lost sales. It's, like I say, it's a very expensive undertaking. License issues. One reason to get a patent is to try to make money off of it, not by potentially suing people, but by licensing them, by charging a license is just like a lease of real property, if you will. It's for a specific term. It allows the licensee to trespass, if you will, on these exclusive rights held by the patent holder. Big license issues that tend to come up is the license exclusive or non-exclusive. Exclusive means exactly what it says. The licensee is the only individual or entity that's allowed to practice the invention. Or is it a non-exclusive license? You license it to multiple people. It's some sort of technology that an entire industry uses, and therefore it's licensed broadly. A lot of times a license will include a certain geographic scope. For example, again, we're talking about a patent that exists, say only in the United States. Maybe the inventor can only practice this at their one or the infringer, the licensee rather, can only practice the invention at their one location, in their shop in Georgia or something. It's more common to have patents where the patentee has secured rights in multiple countries and to license it only for use in the United States. We worked on a deal recently where mining technology, and our client licensed another party to use the technology, but to only use it in Australia, where they do a lot of hard rock mining. And our client, of course, had license or had patent rights down there and licensed it there. And in exchange, our client took a cross license of certain products it could make in the United States. Sometimes, I'm at the third bullet point here, sometimes the particular scope of use can be determined. For example, as a part of a license, the licensee might be allowed to use the invention for only a certain industry. Maybe the invention has multiple uses. There's a medical use for it. There's some other commercial use for it in industry. It's not uncommon to limit the scope to a particular use. There's a term of a license, 1 year, 10 years. The term cannot exceed the term of the remaining term on the patent. That's a trap for the unwary. But within that 20 years from filing, the license does not need to be for the entire duration. The license will typically have an assignment or non-assignment clause, which again can be critical if hypothetically the patent holder has licensed several entities in the business, and another competitor does not want to take a license, and instead they sue that competitor. And we've had this exact case, fact scenario come up relatively recently as well. The accused infringer, to buy a little bit of peace, can not only defend the patent infringement litigation, but if it can take an assignment from an existing licensee, it can effectively moot the litigation as well. So that's a critical clause. And then finally, the payment terms. The only reason I have this on my slide is because it's not common sense, but apparently I'm asked this frequently: what's the amount of a royalty on a patent? And it's the answer is whatever you negotiate between two parties. It's a contract like any other contract. It does not need to be on a per unit or percentage basis. A party can license a patent for $50,000 a year if that's what they agree on. It doesn't have to be, $2 a unit or 3% of revenues. In fact, there's a lot of reasons why one might avoid that. It's simply a matter of contract. So I'm going to jump now for our remaining time and talk about copyrights and trade secrets in a little more detail than we did last week. That's all I have on patents for the time being. We talked last week about what is a copyright, and what we're talking about for copyrights is some sort of an original work of authorship. It needs to be reduced to a tangible medium. And as we talked last week as well, a copyright protects the author, artist, etc., from actual copying. It does not, unlike patent law, it is not strict liability. There needs to be proof that some sort of actual copying occurred. And like patents, the duration of a copyright is limited, but it is a very long term. And again, we talked before, when we think about copyrights, we should be thinking about things like text, drawings, paintings, photographs, music, architecture, software, websites. Those are the most common things that I tend to see here in Montana. The copyrights allow someone to reproduce the invention, to prepare so-called derivative works, those are works that are related, to perform the work publicly, to display the work publicly, and to distribute copies of the work. And we talked last time about how the copyright is actually formed at the moment of creation, but in order to secure it, an individual needs to file a registration. And by secure, what I mean is in order to sue anybody for copyright infringement, and arguably all of these rights are nothing but a ticket to court, if you will, to go sue somebody. The Copyright Office needs to approve the registration of it. Here I've got a sample form of a copyright registration. Unlike patents, this is not drafted from whole cloth. There are multiple types of forms for registering a copyright. Form TX at the top here indicates that this is for a text, a form for registering, say, a website or software code, that sort of thing. There will be a form VA for visual arts, and there's all sorts of different ones. This is a very simple process. The vast majority of clients that I work with in copyright issues, I frankly don't charge them. I just send them to the Copyright Office and say, here's the form, let us know if you really want to pay us to fill it out. But there are typically about, as there is here, are here 9 lines. One of them's, what's the name of the author? Another one is who owns it, the claimant. If for example, the author is an employee of a company who assigned it to the company, what's the title of the work? You can put whatever you want in there. And the other things are pretty self-explanatory. And I don't have in my slides the instructions to this, but it's very straightforward. The instructions are on the website. And like I say, it's occasionally we file these for individuals who are maybe thinking about litigating the issue against someone, or maybe have a very complicated copyright portfolio and want to make sure they don't screw it up. But it's a very, very simple process. And as I mentioned before last week, it is a rubber stamp process. If it looks, it's like the deed to the house. If this looks right, it's going to get approved by the Copyright Office, Library of Congress. Copyright ownership is probably the single biggest pitfall for holders of copyrights. Ownership of a copyright normally resides with the author. That means the person that created it. If it's a software developer, it's whoever wrote the code, the source code or object code, or whatever sort of code was created. The pitfall comes when somebody writes the word "work made for hire" on it, and that sounds like a very legal term. This is a work made for hire. I'm hiring you, software engineer, to create my app. I've got a great idea, but I'm in the trucking business. I'm in the concrete business. I'm not in the app development business. I'd like you to create the app. And you write in the agreement, this is a work made for hire. In the vast majority of cases, that is completely meaningless. Work made for hire means exactly what it sounds like, that the work is made by somebody, the author, who will then immediately assign it to somebody else. It's being done at the request of somebody else, the owner, and they've hired out its work. The problem is only certain types of copyright material can be works made for hire, and software is not among those. There are only, certain types of architectural plans, I think, are included there, but there's a laundry list of things that can be works made for hire. Not everything is in there. The majority of things that people think would be in there are not in there. So what do? It's a really simple process. Instead of saying this is a work made for hire, which is a very defined specific term, there should be an express assignment that if it's an employee, there should be an employment agreement that says we own whatever you create as a part of your job. Or it should go further if there's one specific thing, and it should say, this is owned by my employer. If it's a commissioned work, by that I mean a contracted third party, not an employee, there needs to be some sort of an agreement in writing that specifically says I assign as the author my rights, including copyrights in this work, to the company. Without that, with simply the work made for hire language, there's a problem and it's not going to hold up. I've skipped over this already. Again, there's only 9 categories of work made for hire, and software is not among those. Copyright infringement, I touched on briefly earlier. There's, unlike patent law, for instance, it is not a strict liability. What that means is the infringer of a copyright needs to actually copy the work. That, like, if I have a photograph of a duck on a lake, for instance, that doesn't prevent somebody else from drawing or taking their own photograph of a duck on a lake. They have to actually copy mine. And there's 2 ways to prove that. One is actual copying, which is often difficult to prove. To prove that somebody actually intended to copy it, unless we're talking about an internet image where it's truly identical, pixel by pixel. Actual copying is difficult. The second and more common way of proving it is a combination of access to the copyrighted work along with substantial similarity between the copyrighted work and the accused infringing work, which makes sense. If somebody comes up, maybe I can't prove that infringer slavishly copied every little detail of my drawing, but if they had access to my drawing and they look substantially similar, determined by a jury, then there's infringement. And what are the remedies? Well, there's 2 types of damages. And again, we touched very briefly last time on this, but the copyright holder can collect actual damages. Well, what is that? Again, that's a function of a very expensive expert witness coming in and saying, had this person not, maybe it's a competitor, maybe they sold the artistic work as a, it's easier to think of as a photograph, and we're in the business of selling photography photos. They made X amount. I would have captured those sales if they didn't infringe my work. Therefore, this is my remedy. The other more complicated and more common examples are somebody steals software code. Well, they developed software for a self-driving car and they took 138 lines of code out of 12 million lines of code. What's that really worth? That's difficult to prove. And because it's difficult to prove, for registered works that have been filed with the Copyright Office, the law allows so-called statutory damages. What that means is that the copyright holder can, in the absence of proof of actual damages, the copyright holder can elect to take so-called statutory damages, which a judge or a jury can fix at anywhere between $750 up to $30,000 per work. So if you have one copyrighted work that's been infringed 50 times, that's just one infringement. If you have 50 separate photographs, each registered separately, for instance, that have each been copied once, that's 50 infringements. If it's willful, the jury or judge can increase the amount up to $150,000 per infringed work. If there's truly innocent infringement, the infringer is still required to pay statutory damages, but a judge or jury can lower that amount down to $200 per infringed work. And we talked about this last time, but the advantages, of course, of a copyright are that they are exclusive rights, registration very inexpensive, and they technically exist from the moment of creation. They are limited, though, to a certain period of time, depending on whether the work is published or unpublished. They can never protect the functional features of or abstract ideas. They're not a substitute for a patent, a utility patent. And they don't protect against independent creation if somebody came up with the thing all. So with the remaining 10 minutes left, unless there are any questions in the chat, I want to talk about trade secrets. Trade secrets are now a matter of both federal and state law. We had, there were uniform trade secret acts, which are pretty uniform in most places, adopted by the states. This is not typically, was not typically the realm of the federal government until the Defend Trade Secrets Act, from dating myself now, but probably 5 or 10 years ago. It's now been codified, but the gist of it is technically 2 different statutes. The trade secret is something that, of course, is secret. It's not generally known to the public. And as a result of the fact that it is not known to the public, there's some economic value there. And moreover, the inventor needs, or the inventor, the owner, I'm thinking of the example of a composition, but whoever owns the trade secret needs to take reasonable efforts to make sure that it's kept secret. Which should be obvious. As soon as a trade secret is, the cat's out of the bag, if you will, there's no more secret. There's no more value to it. And that's the downside. A lot of inventions could be protected by either a patent, where we've got the trade-off between a limited monopoly for 20 years in exchange for disclosing the invention to the public, or alternatively could be protected by a trade secret. There we have potentially unlimited protection, but we have to keep it secret. And that can be difficult. When we're, again, to delve a little deeper than we got last time, to determine if something is a trade secret, the court, the judge, the jury is going to look at the extent to which that information was known outside the business that claims it, the extent to which it's known even within the business. If you have a secret process in your manufacturing plant, for instance, you should take steps to limit that information, even internally, and you should mark it confidential. And that's the second 2 bullet points here, I guess. What is the inventor, what is the owner, I guess, in this case of a company, doing to keep it secret? And the answer should be limiting the number of people that know about it, marking printed materials that include it confidential or something like that, proprietary, trade secret, etc. But it should not be known to every new employee that starts at the business. The Coca-Cola formula protected by a trade secret was widely believed at least to be known to only 2 people. I think those days have long since passed, but the point is, even within the Coca-Cola company, you're not going to tell every driver that delivers Coke somewhere what the secret formula is. Other factors a court's going to consider are the value of it. What as a result of this supposedly trade secret information, what value is conferred upon the owner as against competitors? In other words, could the competitors go out and just figure this out in a half hour? Or is this, maybe we've got customer lists. Customer lists are probably the single biggest item that's claimed in Montana, at least, as being a trade secret. And the vast majority of times they are not, in fact, trade secrets. The question, though, that a court's going to ask, a judge or a jury, is how much time was taken to develop that information? Could a third party go out and figure it out in a pretty short period of time? Again, if I'm selling, for instance, screws locally, I sell hardware here in town. Again, another case that we've had. I think I can figure out pretty quickly, if I want to compete in the screw business, who's going to buy my screws. It's probably going to be Ace, Home Depot, True Value, Lowe's. It's going to be my big suppliers. It's going to be local builders. They probably want to buy my screws. that is probably not trade secret information. What might be trade secret information, though, if I'm in the business of selling screws, is that, you know, X buyer out there buys a certain quantity of those screws every month. That would probably be a trade secret. So that's the sort of thing that the court's going to look at. How much time would it take someone all on their own to figure out this information? So what are reasonably protective matters? I talked already about marking things confidential, and I think that's a good idea. It's also a good idea to have a confidentiality agreement with employees. If employees are going to be exposed to customer data, any sort of trade secret information, those individuals ought to be bound by some sort of an agreement that says, I will not disclose this information. I will not use it for purposes that are improper. Exit interviews are another good way to, if you have an employee departing who's willing to sit through an exit interview, it's a good example to remind that employee that, hey, you were subject to confidential information. We want to remind you that you need to keep that information secret. Training is something, again, the bigger the company, the more this may make sense, but you should train your employees, if you're a business, in how to keep things confidential. You should also isolate that, as I talked about. And to the extent it's appropriate, you should have someone formally within the organization review everything that is supposed to go out. In other words, employees can't share mission critical information with third parties without screening it through someone, if you're a big enough company to do that. Non-compete and non-disclosure agreements with employees are good to have. They're also not terribly enforceable in the vast majority of states, certainly Montana. They're going to be limited. In Montana, they really have to be drafted carefully. And you should assume, as an employer, that your non-competes, even if they're drafted by us or someone else, may well not be enforceable in Montana. But I think a non-disclosure agreement that says I will keep stuff confidential absolutely is going to be enforced under most instances, if you get the employee to sign it right off the bat. Further steps to keep things secret. The employee files, and I think this goes without saying probably, but the employee files should document whatever agreements you have with the employees. They should document what efforts have been undertaken to keep something secret. They should, if you have supplier agreements, vendor agreements, those should also be marked confidential, and there should be non-disclosure provisions contained therein if you can. Computer security, and again, this is beyond maybe the legal issue, but these are the types of issues that we frequently deal with. But that is, in a lot of businesses, it's appropriate to limit access on the computer by individual. Only certain individuals can access certain files. We do that, for example, even at our law firm. In certain instances, I can't access we're subject to different non-disclosure agreements, of course, and attorney-client privileges, but the concept is the same. We're limited in some respects from, I can't see every client's information, even if they're a client of the firm, if I'm not working with them. And one of the biggest pitfalls, and we're going to see this more and more, I think, as more people move to the state and come from California and other places, entrance interviews, new employees, couple of things. One, whatever, and this is a matter of employment law, probably more so than intellectual property, but the new employees should sign whatever paperwork, whatever agreements they have on the first day they get there, if possible. This should include the invention assignment agreement. This should include, that says anything I invent in the course and scope of my job, I will immediately assign to the company and hereby do assign it to the company. That should include probably a non-solicitation agreement. I will not leave here and try to take with me all of the people I work with. It should, if there's a non-compete, it should be signed up. It should say, I will not compete in this industry for this period of time. If there is a confidentiality agreement that we're talking about here, that should be a part of that first day paperwork. But among that other stuff, as an employer, you should make sure that, and ask the new employee this to confirm this, that there are no trade secrets brought from a previous employer. That can, if you have a critical employee who had access to trade secrets at a previous business, that can cause some real problems that go well beyond this particular individual. And then, of course, what I've been talking about the whole time, confirm that there will be trade secrets disclosed in the current position, and that new employee needs to make sure that he or she does not infringe those. I've talked about everything there. I'm going to conclude, and again, unless there's any comments, I'll conclude with trade secrets. The advantages, of course, are there's no filing. It's not like a patent. A patent's going to set you back $10,000 to $12,000 to $15,000 over a few years to get it filed. Trade secrets require no filing. Their rights never expire. There's not a 10 or 20-year limitation on it. But they can, in the long run, be very, very expensive. That is all that I have. Kayla, I'm certainly open for any questions if anybody has them. I don't know if I can see the chat or not, if there are any.
I've been watching and I haven't seen any. So if you do have questions, you can go ahead and unmute yourself. Thank you so much, Shane. You did a great job. This was great information.